We look at this central question of Donald Trump's argument in the Jan 6 case. Does he have an absolute made-up immunity that no other president or former president has ever had, that's never been found in precedent, in law, in the Constitution? And as the Supreme Court has now said it will, does that require it must be reviewed in delaying the trial? The Supreme Court has clearly decided to unnecessarily delay everything.
There was no reason in this world for the Supreme Court to take this case.
We could have expedited it more.
We know that Trump's strategy has been to try to delay both federal cases.
The delay itself de facto gives immunity to this former president.
The whole point of this ruling is for Trump to win.
When it comes to the timing and delaying this, that's a win in their books.
The Supreme Court knows that there's a consequential election in November. It's abundantly clear that there is no cavalry coming to save our democracy. Only the voters can do that.
This is where we are at tonight. If you were watching Nicole Wallace on MSNBC around 5 p.m. last night, or this program or others late into the evening, you probably heard about this breaking news of the Supreme Court stepping in when they don't have to, and then doing it very slowly to delay what was going to be the only scheduled trial of defendant Donald Trump for his January 6th actions. The court knows what's at stake. The court knows the timeline. They know how these things work. I want to show you this now in the breakdown. Nicole mentioned doing some math. We'll do it very simply. In December, the Supreme Court first responded to this same question about whether to hear any of this, rejecting Jack Smith's request to say, if you do need to look at this, even though it's been a losing argument for Trump, the idea that he has made up immunity, please fast track it. They said no. Then Trump appealed to the court to intervene, and it spent another 2 weeks just waiting around, then finally issuing that one-page order last night. And then that order didn't exactly say, hey, we'll hold this hearing right away. It pushed the argument date out to the very last 3 available days of oral arguments on the entire court calendar this term, late April, which, as the New York Times put it, clearly bolsters Donald Trump's delay strategy. Now, if you are watching this, but you're not always following how the Supreme Court works, you might say, okay, news anchor, okay, Ari, obviously that's not very fast, but is that just how it is? 9 people with permanent tenure in robes moving at their own slow, deliberate pace. How do you know that that's any different than other times? How does that prove something abnormal, or as some critics have said, flatly partisan about this particular Republican-leaning court? Well, we'll show you the evidence. You'll make up your own mind. But when the court is dealing with exactly similar circumstances, candidates for president, big clashes, things that could affect an election, one coming up or one recently finished, we know the Supreme Court, which operates on precedent, has all of the ability and all of the knowledge and all of the tradition of acting as fast as it needs to. Take just one recent example that I told you about, where I warned people who were thinking, oh, this is going to affect everything, the Colorado case about the ballot ban. I told viewers before it ever went to the court that it didn't have a lot of precedent, so it was unlikely to kick Trump off the ballot. Here's a different point tonight. That case, which turned out to be pretty Trump-friendly from the oral arguments, was one where the court knew exactly how to act quickly.
The Supreme Court announced it will hold oral arguments on the case next month on February the 8th, which, to be clear, in Supreme Court time is light speed.
A fast schedule by Supreme Court standards, but by no means an unreasonable schedule.
The timetable is definitely expedited in Supreme Court land. The only timeline by which they have to operate is really their own.
And we'll show you what that looks like. Trump appealed that case, and 2 days later, January 5th, the court took it. 2 days. They said, oh, we'll take it, and then promptly scheduled those oral arguments that we covered. The headlines out of that hearing were very clear. The court likely to side with Trump. So on a Trump-friendly case where he wanted fast action, they moved fast. This is a case where Trump wants to move slowly, because in that other case, he needs to get back on the ballot. In this case, he just wants the trial to go away. And the last time the Supreme Court had to weigh in on an actual presidential election that had occurred, which is different than the ballot thing, right? That's coming up, was the very famous case in 2000 of Bush v. Gore. I told you we'll show you the evidence tonight. And then you can look at precedent. The court and the judges claim they use precedent. Well, in an important election case with all of those consequences and also complexities, the court again showed it could act with real speed and urgency on a significant presidential election issue.
The stunning announcement from the U.S. Supreme Court granting an emergency request from the Bush lawyers.
This may well be the single most historic decision of the Rehnquist court.
Both these men believe they should be the next president of the United States based on the law and on the politics.
I think there is a general expectation that the court will act very quickly.
The U.S. Supreme Court has just released its ruling.
The recounts would not continue. It's an all-out victory for the Bush team.
There you see some of our MSNBC veterans. That was Dan Abrams and Pete Williams in front of the court. And boy, did they act quickly. We'll show you the timeline. The Florida Supreme Court had that recount call on December 8th. 3 days later, December 11th, the court heard oral arguments. And a day after that, they rushed out their decision. That's 5 days total from appeal to decision. So the Supreme Court knows how to act quite quickly, even on complex, high-stakes presidential conflicts when it wants to. Here, even though they don't need to act that quickly because there's not a handoff of presidential power coming up, it's not going towards January 20th, but here they are on a much slower side. Think about all the precedent you just saw. Think about how Donald Trump's lawyers have said one thing over and over in the Jack Smith case. It should be delayed. We know that because when the case was first filed, they were proposing a trial date of 2025 after the election. They lost that, just like they lost the immunity claim. But what the Supreme Court did late yesterday, even before ruling on the merits of this case, was hand the Trump lawyers the win they needed on the timeline. So take a look. We mentioned February 12th, Trump asked SCOTUS to intervene. They took over 2 weeks, not 2 days like in the other case, to just grant the cert. That's what we learned last night, and then put the oral arguments at April 22nd, the last possible week on this calendar, and 7 weeks out from today. This is a win for Trump because delay is the strategy. For Donald Trump's lawyers, delay means win. I've shown you our sort of timeline here of all the cases. By scheduling this case at the end of April, we have the precedents and the expertise to note that that means the ruling might not come until late June. And then if the Supreme Court upholds Trump's loss, remember, he's already lost on the immunity issue both times it's been heard, well, only then would these pretrial proceedings begin because this same court last night not only delayed the case, but issued what's called a stay, which just means a freeze of any other actions in the underlying prep for the trial. Now, if you want to play this all the way out, as Nicole and I were discussing, it gets pretty simple from here. Trial date could land as late as September or October in the middle of the general election. And even if the court does rule before late June, the justices have already delayed this thing by months, possibly preventing any such trial. So I will repeat what I mentioned because it's the bottom line. If you're saying, okay, Ari, that's a lot of different calendar talk, here's the bottom line. Very few people expect this court to make up new precedent that says politicians can never be prosecuted. That's just not what people think is going to happen. And as mentioned, Nixon took a pardon precisely because he could be prosecuted. But they may very well issue a late opinion that claims you can put politicians on trial while acting to moot and prevent this very trial of this politician. How, Sway? How would that ever make sense? So, does that mean there's no trials left? Not exactly. Donald Trump, unlike every other former president in both parties, created so much criminal evidence on himself that he's actually facing, as you may have heard, more than one criminal indictment. So there is still a criminal trial over those hush money payments and how they were characterized in New York. That trial is scheduled for March 25th next month. What we can tell you tonight is that trial, the one you see now on our calendar there, might be the only one that actually goes down before the 2024 election. There is no Supreme Court ramp to deal with it or delay it. It is scheduled. It is now the only one that is scheduled. So it could take on an even larger significance. You take this all together tonight, and what you see in the evidence that I've shown you is the court not only can move more quickly, but it has. It moved more quickly recently in a case that Trump wanted speed on. It moved quickly in very controversial matters like Bush v. Gore, where it knew that roughly half the country or one of the political parties was probably going to be pretty unhappy. So why is it on this case with a very simple losing argument Are presidents immune? Do they never go to jail? Are they immune for life? Do we live in a dictatorship? None of these have been close calls in history. On such a simple matter, why are they suddenly going so slowly in a way that only helps one person, a person who is a criminal defendant, getting special treatment to delay the very criminal trial that the current Justice Department has said is a matter of national import?